Hello, everyone. Thank you so much for joining us for the latest segment of Affecting Change, EFF's live stream series, where our panelists tackle the latest issues in civil liberties and human rights in technology and the digital world. My name is Beryl Lipton. I am a senior investigative researcher at the Electronic Frontier Foundation, and I will be your host for today's discussion. Before proceeding, we have a few items of housekeeping to go over. This will be a recorded session, but only video of our speakers will be included. Please join us in the official chat via Twitch at eff.org/livestream. In this chat, you can drop your questions throughout the program, and our guests will answer as many as they can at the end. And if you're comfortable, we encourage you to type a hello in the chat window now and let us know which part of the world you're tuning in from. For those of you who aren't familiar with the Electronic Frontier Foundation, EFF is a nonprofit whose technologists, activists, and attorneys have been fighting for your online privacy and free speech since 1990. You are the reason EFF can take on this important work. And if you'd like to help us in the fight to defend your freedoms, please consider donating at eff.org/supportchange or by picking up a cool bit of EFF merchandise at shop.eff.org. With that, please join me in welcoming our speakers today, Bill Buddington, Lee Tien, and Joe Mullen. Bill is a senior staff technologist who leads our cybersecurity policy team at EFF. Lee is EFF's legislative director. He manages EFF's work in Congress, Sacramento, and state legislatures nationwide. And Joe is a senior policy analyst at EFF, where he works on patents, encryption, platform liability, and free expression online. Today's conversation is meant to help provide some background and context on issues that will be facing us in the coming months and years. A new congressional session is underway, and on Monday, Donald Trump will be stepping back into the US presidency. Every new administration brings new challenges, and privacy and free speech advocates are recalibrating their strategies to navigate the priorities of the incoming leadership. It's already clear that technology policy will play a key role in the coming years. But in what ways? Today, our panelists will share what they anticipate under Donald Trump's second term in office. You'll learn about the latest in the ongoing fight against US mass surveillance, why lawmakers are attempting to force age verification online, and what's next for consumer privacy in the digital age. Finally, we'll take some viewer questions and share some ways that you can protect your rights online. Let's begin with the federal government and EFF's fight against mass surveillance. Lee, you've seen legislation that facilitates mass surveillance, legislation that EFF consistently opposes, get renewed over and over again, like Section 702 of the Foreign Intelligence Surveillance Act, also known as FISA. Could you please give us a bit of foundation around what FISA and Section 702 are, and more importantly, help us understand the problem with these particular laws and the overall system in which they're operating? Oh, sorry, quick unmute, Lee.
Sorry about that. So really, there are three main distinctions that people need to keep in mind about national security surveillance. The first is that there's a real simple distinction between what we think of as ordinary law enforcement surveillance and then so-called national security surveillance, which we've become very used to since 9/11. So the Supreme Court, unfortunately, has always given the government more leeway with national security surveillance, which means that a lot of the constitutional safeguards that we associate with the standard criminal procedure, Fourth Amendment, are really not honored the same way in the national security realm. So that's point one. Point Two is that what we're talking about today, FISA or 702, these all fall to the national security surveillance bucket. Now, the funny thing is that the original FISA, which came about in like 1978, was actually intended to try to rein in the intelligence community. And we call that these days classic or traditional FISA. You know, a lot of civil liberties advocates hated the classic FISA and still do, but it is actually more protective of civil liberties than what we've had since 9/11. And since 9/11, you know, beginning in the Bush administration, but continuing throughout every political administration, the government's been engaged in what started as the terrorist surveillance program, a kind of dragnet surveillance that I won't go into here because we talk about it a lot on in blog on our website. But the key point of it is that it was a secret system that was deployed on Americans without any kind of notice, without any kind of legislation. And EFF fought against it in court thanks to whistleblowers and folks who provided basically what had been classified information. And that was the only way we were able to even bring a lawsuit. And yet, at the end of the day, that got kicked out of court by the acts of both Congress and the president. And that is what now we think of as the Section 702 program, transformed that original secret surveillance program. And it is far less tied to any kind of sense of constitutionality than the classic FISA was. So that's, you know, those are the main sort of legal points that folks should remember when we're talking about federal government electronic surveillance. Now, Beryl, you asked what the big problem with this is, and you know, I think a lot of people would say, "Oh, it's the Fourth Amendment. They are not following the Fourth Amendment," and that's right. But even bigger than the fact that they're not following the Fourth Amendment, in my opinion, is that there's no accountability for this kind of secret surveillance for a number of reasons. A, the executive branch, the intelligence community, gets to classify information so that the public, like us, can't see it. But even within the government, the intelligence community gets to decide who needs to know. So members of the House of Representatives, for instance, don't automatically get read into these programs. They don't automatically get to even talk about it with their staff. The power of the federal government, and especially the intelligence community, to decide who gets a clearance, who gets to actually even know about things is really quite strong. So it's really hard for Congress to push back and say, sorry, President, we need to be able to see these things. And then in a structural sort of trick, you know, certain members of Congress, like the intelligence communities, they get read into things. And this creates an institutional incentive for them to hoard information, for them to be able to control what other members know about things. And, you know, the incentives of this kind of structure are very, very much towards secrecy. So, you know, we have a system of national security surveillance that is really led by the intelligence community and is able to keep a lot of detailed information about what they're doing, whether it even works, away from both the public and from the folks in Congress who are largely supposed to actually regulate that. So that is, in my view, you know, the big problem with this system is that there's just no transparency and no institutional mechanism for finding out what they are doing. I'll stop there.
So it sounds like there are great imbalances even within the government and within Congress about who gets access to some of this information, who gets to actually provide some of the oversight here. So could you tell us, where did Congress leave us at the end of last session? And sort of where can we expect Congress to go in maybe the first few months?
Well, I feel like it's oversimplifying, but really there were two things that were big that happened last year. The first is that there was a lot of concern about the purchasing of data by both law enforcement and the intelligence community. I mean, one of the problems of the modern national security surveillance system is that so many private entities collect our data. They hoard it, they use it for advertising, they use it for other things. And then the feds get to suck that up. The overall surveillance problem isn't just a government surveillance problem, but right now, we can't keep the government's hands off of it. Many of the civil liberties groups worked on a bill called Fourth Amendment is Not for Sale Act, which would have attempted to put some limits on the power of the government to actually acquire this kind of data on the open market. But that failed. The other thing that happened toward the end of last year is that we renewed the 702 authorization. That is something that the intelligence community always gets. We try to stop it every time, but they get that through a lot of times because national security is like a magic word for politicians. And one of the biggest sort of scandals at the end of the year was that the intelligence community snuck in an expansion of FISA to include a large number of electronic communication service providers that are not well defined. And so essentially they enacted something that is secret law because what it says basically is there's a secret court opinion, and this law now reaches these entities that are named in the secret court opinion without actually saying what those entities are. So it's basically citing to something that you can't see. And, that just compounds the lack of accountability and lack of transparency in the government. So it's really quite an abomination. And that's one of the things, those two things are probably the main things we're going to be dealing with over the next couple of years, because 702 is being reauthorized in 2 years. And so we have 2 years to try to build up some force to stop it.
So yes, going to be very tough to break down some of the blockades that are protecting the government here and their ability to spy on us. What would be sort of EFF's best case scenario for how things could play out with Section 702 or with some of these other proposed laws like the Fourth Amendment is not for sale? And how is EFF maybe thinking about how to deal with some of the various incentives at play that are going to be continue to be obstacles?
Something terribly different today than we were saying years ago, but the mood of the public seems to be a little more privacy sensitive. There's, ever since this Supreme Court and decisions like Dobbs, there's been a renewed concern about personal data and privacy in a law. So we're hoping that concern for privacy feeds back into Congress, into the public. The other side of it is that folks need to be more skeptical about the concept of national security, which gets marched out to defend a lot of, frankly, indefensible things on the part of the government. And, I will just note that just this past couple of weeks, we've been dealing with the things like the expected shutdown of TikTok because supposedly this is a national security threat that China has access to a great deal of personal data. Uh, and yet, of course, many companies have access to personal data about us, and it's being sold or shared all over the commercial world. So is growing skepticism in some circles, I'd say, about the, really how good is the national security case for anything like that. And maybe we should demand that when the government claims national security, they actually display some evidence to support their claims. So, that's my sense of hope about this, is that maybe people are going to wake up both on the privacy side and on the national security side to realize that the government owes us better answers.
Absolutely. And I'm really glad that you brought up national security and specifically the TikTok conversation, because I'd like to turn to you, Joe. Obviously, a lot of the work that we do at EFF revolves around protecting the First Amendment in a world where so much of our communications and expression happen online, including on social media. And as Lee mentioned, the Supreme Court this week is considering the constitutionality of a law that would require the sale of TikTok, effectively banning it in the US. Could you, Joe, please walk us through how EFF thinks about this proposed regulation of TikTok and how organizationally we consider the regulation of social media and the value of online spaces for everyone?
Yeah, thanks, Beryl. So what's going on with TikTok is a bit different than some of the other also wrong-headed and unconstitutional efforts we're seeing. As you said, what we're seeing with TikTok is it's a straight-up ban that got passed through Congress, a ban on a piece of software that more than 100 million Americans used. Current estimates are around, pushing 150, and probably over 1 billion users worldwide. The amount of speech on there that is even political at all is a minute part of that content. People are talking about all the things that people talk about in human conversations, their families, their kids, their businesses, their friends. And it's just a vast amount of speech. And the divestment sort of excuse to make it sound not like a ban is just really a fig leaf, because if you force it to change owners, that makes a big difference. Ask anyone who used to use Twitter a year ago. It makes a big difference who owns the platform, and especially if the government is essentially in charge of the sale and has say in it. So this is a law that passed the House and all of Congress because politicians didn't like the content they saw on TikTok. That's what it's about. We know that's what it's about because they said they didn't like the content they saw on TikTok. They don't like how there's 2 wars that have broken out in the world, and there's millions of people talking about it on TikTok, talking about Ukraine, talking about Gaza, on both sides of those conflicts. And, politicians see things they don't like. And what we're really seeing here is a culmination of an effort to game the refs of the online content moderation system. We have 2 parties, each of which thinks they have something to gain if they can really tweak the rules of content moderation and content control to be less than the First Amendment. They want to get involved. And we at EFF think that's not the way forward. The First Amendment was the right way to moderate American discussions about politics and everything else before the internet, and it still is. And it works well, combined with Section 230, which we can also talk about. But the TikTok question is now at the Supreme Court. It's just an unconstitutional ban on free speech. As Lee said, the national security argument was used pretty heavily. The US government has filed plenty of evidence about why TikTok is bad, sealed. And they haven't really made that case at all. But here's another thing. Actually, it doesn't matter that much what the content on TikTok is. If you believe in a country that values freedom and values the First Amendment, it's okay to look at it. actually, there are Supreme Court cases about Americans having a right to receive foreign propaganda. Actually, open magazines, pamphlets. During the Cold War, people said, I want to get this literature from the Soviet Union. I believe in non-American systems of government. And, the government tried to cut those people off. And actually, you have a right to even view explicit foreign propaganda. That's your right as an American. And I think what we want to do, the TikTok ban is wildly unconstitutional. But the argument we're making is not just that it's illegal and the court should get the law right as it has in the past, but also that, we need to defend the value system of the First Amendment, right? I mean, if you're a strong democracy and you're concerned about messages coming from non-democratic countries, one good thing to do is, well, don't act like them. We can actually say we're a strong democracy. We have a lot of people in this country with very different views who are allowed to think freely about whatever issue they want and speak about it. And we're not going to try to, just like we're not going to try to control the mail they get, even if it's from a foreign country that we're sometimes in disagreement with. We're also not going to do that on the software and on the internet realm. So some of the same values are not really changed in that regard. But the TikTok question is at the Supreme Court. We filed a brief explaining some points. A lot of our allies have filed briefs too, and it's kind of a question of whether the court will hew to the line that has, kept us free, had a strong First Amendment rulings for the past 75 years. We hope they will here.
Yeah, and some of what you've touched on is that this is not just limited to the Supreme Court, to this particular case. What we're seeing is more elected officials looking to remove this harmful content and also kids' access to certain websites. Can you explain, what is this? Where do these efforts stand right now? What do people or should people know about what's happening on this front at some of the other levels of government?
Yeah. So there have been different bills pushed forward at the federal level. The one that we've heard most consistently about over the past couple of years, and that's really gotten the most traction, is called the Kids Online Safety Act. And this is a straight up censorship bill. It's pretty open about it. You get to a section where they talk about how websites will have a duty to get certain content that politicians think is harmful, vaguely defined harms to minors, and they'll have to take steps to make sure that content doesn't get seen. The bill has gone through a bunch of iterations, but it's always had that at the core of it. And, this goes back to what I was saying earlier, like TikTok was one version of that. But when you see KOSA having, KOSA's KOSA, the Kids Online Safety Act, when we see that bill having, unfortunately, I think misguided, pretty strong support, at least in the Senate, from both parties, I think what you're seeing is that both politicians in both parties think they will have something to gain from getting in that mix and kind of thinking they will be the authorized referee of internet speech, right? Them or their people. And it's a very misguided effort. I mean, we had a very contentious election that took place in November, and people who voted for the other party are now going to be facing an FCC and an FTC that might do things they really disagree with. So the right thing to do back then is the right thing to do now, which is to not bet that people you like will take control of the internet and silence your opponents. You can't censor your way to justice or fairness or the values that you want. The only good answer in a democracy where we try to persuade each other is more speech. But we have seen a lot of, and KOSA, it now will be enforced by the FTC. So when we think back to that election and the passionate feelings that a lot of people had on both sides, you really don't want to bet that FTC involvement in internet content will come out your way. To get into some of the specifics of things like KOSA, and they've changed some of this wording, but platforms would have to take down content that would cause anxiety, depression, eating disorders, substance abuse. And then they changed it. They took out anxiety and depression, but they replaced it with serious emotional disturbance. Not really clear what that changed. But there's some huge problems with this. And we all know there's bad content on the internet. Like, I know there's stuff I don't want to see, and I certainly don't want my kid to see. That's true for everyone. The point is those decisions get made within individuals and families and not by politicians, not by the FTC, not by your state's attorney general, and not by the state attorney general in a state that's far away from you who you didn't vote for. The problem with the harms is they're vaguely defined. There's tons of gray area, and there's certainly no software system or even human review system that's good at differentiating between, for example, content that, say, promotes alcohol use or abuse and content where people are talking about alcohol use or abuse, talking about maybe being in recovery, talking about behaviors they used to have that they don't want anymore, talking about behaviors of people around them in their family or in their class that they're really concerned about. That speech is really hard to moderate, even for people, and certainly it can't be done with software. So the idea that there's this kind of, obvious corpus of what is harmful, and that people agree on that is completely wrong. And you would think people, some of the hot button examples where people strongly disagree about things are things like, they're obvious, right? It's the biggest political fights we've had in the last 2 years. Abortion, LGBT rights, and healthcare. Like, those are just treated vastly differently in different states. And it's somewhat astounding to me that we still have so many leaders in both parties that think they're going to somehow get the upper hand in those conversations, because you don't want to bet, if you're a Californian, that the content that would be harmful to your kids should be decided by, the attorney general in, I'll say, Tennessee, which is the state of Marsha Blackburn, one of the co-sponsors of the bill. And conversely, people in Tennessee shouldn't have to hope that the attorney general in California or that the FTC will, moderate content in a way that's good for them and their family.
Yeah. And I think you've touched on this throughout what you've shared here, but I just want to sort of underline, right? Some of these laws, like COSA or some of these age gating laws in the states, have strong support from both political parties. And it sounds like there's some misunderstanding around how some of the technology works. It also sounds like there's a misunderstanding around how the transfer of power works. Are there other things that we should really be keeping in mind about what people on both sides of the aisle are missing here in some of these conversations?
Yeah, the last one I would mention is what you just mentioned, age gating. We're seeing a lot of laws on both the state and federal levels, and the state laws are passing. So wherever you live in the US, this is a good thing to check out now. So these are age verification laws that are basically, going to require ID checks on the internet. And we've never had an ID check system on the internet. That's not how the reason the internet has been so successful and has, changed everything about how we communicate is because it was designed as an open system, with trust and open standards. And that still should affect how we think about it and run about it, even though, again, we acknowledge there's bad stuff on the internet because humans communicate in ways that are sometimes not great. But we think COSA will lead to age verification because the way it was written is all about harm to minors. And, the platforms will be left with a few choices, right? What do I do with my forum where people are talking about drug and alcohol use? What do I do with my forum where people are talking about being depressed? Well, they can delete it. And some of them will do that. We'll just lose it. The other thing they can do is they can just say, no kids allowed here. And we have to be 100% sure about it because we don't want to get sued or prosecuted by the government. And so they're going to ask for ID checks. And then on the state level, you have ID check laws that are right now geared towards, explicit content. So adult erotic content, if it's a third or more of the site, and they are, saying that it's kind of trying to make it seem as if these laws will begin and end with pornography. that people don't want their kids to see. But it's not going to, because that stuff ends up really being in the eye of the beholder. There are already so many examples of things that were misidentified as being explicit when they shouldn't have. We've seen so many social media sites with differing standards for gay and straight people. There's all kinds of problems with this content, with identifying this content. And the other thing is, there's so many mixed use sites. I mean, think about a site like Reddit, where it's like some of the content is marked as adult only and some of it's not. So sites will have to go through movie sites. I mean, you know, we could have a situation where you really shouldn't have to upload an ID to watch an R-rated movie on Netflix. And a fundamental misunderstanding, and we get this question a lot at EFF, is like, well, people have learned to live with ID checks in the physical world, and they feel like it's not bad. They feel like it's not bad that someone checks an ID before, you know, a young-looking person is able to like buy alcohol in a store, buy tobacco, right? But an important thing is, online ID checks are not, and mathematically cannot be, anything like the momentary in-person ID checks that we're used to in the physical world, where you're holding your ID and you can withdraw consent. Online ID checks are going to be uploads of government mandated ID cards, and they're going to be databases of who viewed what site. So we're going to have logs of who has gone to sites with explicit content on it, right? I mean, that is already beginning in the states that have passed these laws. And that's a privacy and security risk. I mean, frankly, they're talking about TikTok. It's a national security risk to force our companies to maintain logs of who has gone to erotic content sites or who has gone to other types of controversial sites. The best way to protect people's privacy is to not collect that stuff, not associate it with government ID. And, you know, if we knew our ID was going to be uploaded and kept with a pinky promise that we'll keep it safe every time we bought, you know, a 6-pack of beer, if people buy cannabis products, if people go into a bar, we expect logs not to be kept. And once they start getting kept, they're going to be a real danger, because police will be interested in getting them. Or other bad actors, you know, criminals will be very interested in getting them too. And it's not just going to be people in the US, right? Like, if you think there's no way that your local DA would, you know, try to get someone in trouble or humiliate someone for, you know, viewing adult content online, think about another state. Think about what might happen when you cross a border and go into another country and deal with their police once these systems are in place. So the whole system of online ID checks is moving forward at an alarming rate. And we fought against it because there's no way to do it without losing our rights as adults to do free and anonymous communication on the internet. And sometimes you do need to speak under a username anonymously. People want to get information about all kinds of sensitive things, health things, and we can't lose that right. And that is the point that we've been making at EFF, and we've got to make it even stronger in this year to come, when we're going to see, especially at the state level, a lot more of these online ID checks laws. If you're in California, there was a bill last year that didn't pass. Ultimately, it died in committee, but we expect it to come back, and it's a great one. We are going to be asking people to reach out to their legislators as we see those kinds of dangerous bills come forward.
Thank you so much for all of that, Joe. And I think you sort of mentioned something that I want to turn and ask Bill a bit more about, because there are a lot of privacy and safety concerns that are affecting all of us in the consumer space, and really are building upon some of that logging and tracking of online behavior. One issue that we work on here at EFF a lot is the problem of this mass data collection and the sales of that data. And at the heart of this issue are data brokers. So Bill, could you help our audience understand what a data broker is, how they collect that data, and who uses and buys this type of information?
Yeah, absolutely. Data brokers are just that. They deal in the private data of ordinary people, and they gather that information often from public sources. So you'll see them gather data from voter rolls, for instance, property records and county records. So these kind of public sources, and increasingly from online sources as well. This may come in the form of, say, an app that you install, having a SDK, software development kit, that is embedded in that app, and that communicates out to the data brokers directly. This also might come in the form of real-time bidding. So we recently had an article published about how exactly this works. Lena Cohen, one of our technologists here at AFF, explained exactly how this real-time bidding data broker nexus works. So what happens is that when an ad is going to be displayed on someone's page, then there's this very fast automated auction that happens. And there is the advertising networks, which know exactly how much an advertiser is willing to pay for a bit of information to be displayed on a user site, given that they want to advertise to a very specific market segment. And this is all based on the information that they have about users. It gathers a lot of troves of information from your browser to provide these ads. And then even if you lose that bid, it is going to give that information to the bidders, even if they don't succeed in placing that ad. So this real-time bidding system is used to gather troves of information about you too. So really SDKs and the online bidding ecosystem. And these data brokers using these sources, one is called Mobile Wallet, which is participating in the real-time bidding ecosystem. They were recently hit by an FTC complaint in December. So these data brokers are basically clearinghouses for personal information about ordinary people. And what happens is that this data winds up in the hands of law enforcement. It winds up in the hands of the intelligence community through tools such as Locate X, which was we caught a glimpse of in actual screenshots a couple of months ago, and 404 Media reported about it. It's provided to foreign governments so that foreign governments can often track the location of those that are deployed overseas. And it's also provided to, well, just basically anyone that pays for it. There's been numerous, reports in media about how you can buy troves of social security numbers for pennies on the dollar. And this wasn't possible 20 years ago. This is a new phenomenon. And this is an increasing problem that regulators are kind of starting to be aware of. But really, ordinary people protecting themselves have taken that first step to protect themselves against it. And the ways that they do so are kind of two different methods, right? One is protecting yourself at the point of collection. And for that, we have an excellent tool called Privacy Badger that we develop here at EFF that simply blocks those trackers from gathering that information about you. It stops at the point of collection, these third-party trackers from tracking you and your movement across sites and gathering that information. So there's that method, the technical method. There's a lot of tracker blockers out there. You can even combine them to get that extra protection. And then there is kind of a more manual process of removing yourself from these data brokers. And there's some recourse that we have here These sites do allow you to remove your information from them. There's, kind of first party and third party data brokers. There's a lot of data brokers that derive their information from first party data brokers sources. So if you remove the first party data brokers sources, then the third parties will eventually time out and be removed from them as well. So in order to remove yourself from data brokers, you could either pay. There are paid services, Optory and there's others out there that have been kind of reported on. And there's a great review of different data broker sources by Consumer Reports for Yael Grauer, reported on how you can remove yourself from these data brokers, either through paying for a removal process to do so, or manually going and doing it. Yael maintains the big ass data broker opt-out list, where you can actually go and do that manual process of deleting your information yourself. Unfortunately, it takes a lot of time because they don't necessarily make it easy to remove your data from their site. And when often when I'm in trainings, I encourage this as a group activity. It might be tedious and boring to go through these sites yourself and do this, but if you gather some friends and have a delete my data party, then you can kind of perhaps you might call it collective suffering, but I think it's also a cleansing process. Getting your data removed from these sites can be incredibly empowering, and that way your information doesn't funnel through this large ecosystem, going to anyone who wants to pay bottom dollar for that.
Bill, thank you for going over some of the ways people can sort of cut off that stream of information. I want to know what regulations and laws actually help cut off access to that information also, and also going into the new administration, what changes do we expect to see to some of the regulatory agencies that actually oversee these data brokers and might put limitations on data brokers in general, or data brokers that specialize in specifically our locations?
Yeah, we've seen some good state level laws that will remove data at the point of collection. So we have Illinois' Biometric Information Privacy Act, which limits the amount of biometric data that data brokers can get. There's also in California the Consumer Privacy Act, and that protects Californians from massive data collection in some ways. And as Lee mentioned earlier, there was the proposed Fourth Amendment is not for sale act. Unfortunately, we did not see that pass, and we do need strong federal data protection in order to make sure that this out of control industry is reined in. You have these data brokers that are able to collect, in the report from 404 on the Locate X tool, our very movements across, when we traverse, our location, and our location data is provided in very kind of easy to use click and point tools to law enforcement or anyone. In that report, they had someone who was a private investigator who said that they will work with law enforcement at some point in the future. And they're like, well, okay, good enough, and gave them access to that tool. And this is, when you go grocery shopping, when you go to work, when you drop your kids off at school, this is extremely private information. Location information has been acknowledged to be private information that should be protected. But unfortunately, we haven't seen the legislative appetite to tackle this problem. And we have seen where we have seen initiatives, they've failed. So we keep on harping this idea because it's extremely important of getting a good federal privacy law enacted, one that allows regular people to sue those that abuse their data, and that's called a private right of action, and one that doesn't preempt states from enforcing and passing stronger privacy laws that are better than the low bar of the federal privacy law that we might see. And there are some actions that federal regulators have taken in, especially the last 4 years. And yeah, we can talk about some of the actions that the FTC, the Consumer Finance Protection Bureau, and some of the newer things that are coming out of the FCC and DOJ as well. I'd be happy to talk about that.
Yeah, do you mind touching on that briefly? Sure. Some of those actions.
Yeah. So, in terms of location data brokers, those that are collecting our locations and linking them together. In 2022, Kochava was hit with a company called Kochava was hit with a suit by the FTC. And this past year, in 2024, we've seen a lot of appetite in the FTC of banning the selling of precise location data, as we saw in January with the companies Xmode and InMarket. And then at the end of the year, in December, we saw Grady Analytics, which is owned by a company called Ventel, and Mobilewalla, the one that I was kind of gathering information through real-time bidding, banned from selling and disclosing sensitive information or location information. So we have seen some regulatory appetite to limit this just unaccountable problem and rein it in some. And whether we'll see that continue, I think depends on what the priorities of the incoming administration are. I think I am hopeful that we'll see some continued action on the part of the new chair of the FTC, Andrew Ferguson, to continue some of these aggressive actions against those that are abusing our data.
Yeah, I hope so. A lot of spooky stuff in there. We will be turning to audience questions soon, but I wanted to do a quick speed run through the panel on one topic that is omnipresent in our current technological conversation, and that is artificial intelligence. And there are lots of different things that people mean when they say AI, and a lot of different ways that it could be applied, but it is certainly part of a lot of questions that we get. And so I'm hoping that each of you very quickly might just go over what where you see AI appearing in some of the work that you've been doing, and how you're thinking about AI's place in some of these bigger conversations about the ways that we live our lives. Would anyone like to volunteer to go first?
Sure, I can start. I think that we see a lot of AI working into what was machine learning, and then AI working into, for instance, the decision about who to grant asylum. So, we had this recent suit by Refugees International that is looking to have the Biden administration reveal how it uses AI in decision making for who was granted asylum. We see it working into sentencing, and a lot of the ways that we saw machine learning as the kind of problematic area, and algorithmic decision making as a problematic area. We see now with more like advanced AI decision making, and I think that is because of its very nature, because of the way that that AI learning models work, somewhat more nebulous and unaccountable. We can't simply audit the code because the ways in which AI works is just more complicated, and the accountability of the systems become kind of more nebulous on how to actually rein them in.
Thank you, Bill. Joe,
Yeah,
what do you think?
sure. I mean, to some degree, I find the argument we're making over and over again from EFF to lawmakers in the US and around the world is that we're in the position of having to explain to people that software is not magic. There is no software magic that will solve these deep human problems, including crime, safety, public health issues. And so, it ends up factoring into our battles, but the rules, of how to do something right, including how to do a hard job right, don't really change. So like, as an example, we fought this, basically it was a message scanning proposal in the EU that still has not passed yet, thank goodness. But that would basically, in the name of finding child abuse material, would kind of pressure or mostly require scanning on possibly everyone's messages, files, pictures that are exchanged, whether it's in a chat app or something else. So, this is technically a terrible idea. There's a great technical paper called Bugs in Our Pockets that explains why you don't want everyone's phone to be working against them. But in the beginning of that, a top EU official actually said that they were also confident that they would be able to monitor even text messages beyond trying to match images that could be abusive images. They thought that they could look at text and use AI to figure out who might be a child predator by analyzing people's text messages. And they actually put that out as a feature. I mean, that this would help them get this passed. Really insane idea that, we're going to have software that's going to identify people committing crimes, in the next year. So it's incredible that someone elected to a position of power would even say something like that. Of course, they backed away from that position, but software isn't magic. People have to take accountability for their decisions, including tough decisions, and that hasn't changed.
Thank you. And Lee, do you mind rounding out this question?
Yeah, sure. I can make this short and sweet. Look, earlier I was talking about how secrecy is a huge problem for reining in surveillance. It's hard to regulate anything when you don't know what they're doing, and they won't tell you, and they don't have to tell you. AI is just going to make it even harder for the public to see what's going on. So not only can they hide behind, oh, we need secrecy, and they hide behind, oh, we can't tell you what the law means. They can also hide behind, oh, well, it's very complicated, it's very technical. Our machine learning has figured this out, and sorry, can't explain it. It's just going to make things worse. Now, we've written a blog post, or not me, Matthew, one of our analysts has, on the EFF website, that goes in deeper into the issues of secrecy and AI for military and national security action. So I'll stop there. Thanks.
Thank you, Lee. I want to turn now to audience questions because I know that we have gotten a lot of them throughout this conversation. And perhaps I'll begin with a question, I think, for you, Joe. Could you touch on bans on smartphones in schools worldwide and sort of what the thinking is on that?
I would just say that is people are saying ban to mean a lot of different things. So it's kind of impossible for us to answer that question in like a global way. There's a huge span of things right now, and we're kind of watching and waiting to see, right? I mean, because what people are talking about is also not what's really happening at this point. So I would just say we're watching that very carefully. You've seen everything from proposals of like don't bring a phone to school to like, please keep your phone in your backpack during class, which is like two totally different sets of rules that might be referred to with the same language. So at this point, we're kind of seeing how it plans out. And again, but the civil liberties movement has spoken in about this stuff. I mean, the basic things are that, like, young people do have First Amendment rights. Those don't disappear. They don't disappear in a school. But of course, there are rules in class that are not going to be the same as the rules on the street corner. Those are kind of basic, like 100-year-old principles of civil liberties. And in terms of like smartphone bans, that's at this point, it's kind of words on paper. And I think we're going to see what we need to react to this year. We just don't know yet.
Awesome. Thank you. Another question we got, would any of you want to jump in and sort of just speak to the relative risk of comparing surveillance here to the sort of surveillance that is conducted in other countries?
If this is kind of on, I think this kind of speaks to some of the TikTok ban concerns that we were talking about earlier. And I think that when, for instance, you are banning a specific app rather, at the point of distribution, rather than, regulating what data can be collected about ordinary citizens at, the point of use, then you're bound to fail in that approach. You have a ban on TikTok, which is now having people flock to things like Red Note. And, since you're not actually limiting the privacy invasive behavior that can occur on a device, and simply banning the one instance of the app that has been a flashpoint in the political moment, you're actually not protecting people and having them go to an equally censorious app. So that's all I'll say about that.
I mean, there are other very bad surveillance regimes. We mostly need to focus on the surveillance and injustices happening to the places where we work, which is mostly the US and a little bit in some other countries where we have connections. But, there's countries that have vast surveillance schemes, including, China. And why would we want to, if we're concerned about TikTok, China is a country that banned Wikipedia, right? In all languages. Why would we want to step up and be the next country to ban a big popular app? How is that going to make us the better party? It will just put us in a process where we're also trying to gain the upper hand in the world by limiting people's freedom. So
100%.
Great. Another question was related to Section 230. And this commenter writes, when created, applied to comments and user content online, but now X and Meta use algorithms to filter what users see. So how do we make them responsible for that filtering without throwing out Section 230 for unfiltered content?
I could talk to Section 230. I'm not quite sure about the filtering stuff. So Section 230 continues to be under attack. We've seen multiple presidential candidates from both parties denounce it. But Section 230 is a great idea. It's what lets us live out our First Amendment rights online. The only limits that Section 230 sets is, it says that just like in the offline world, we are responsible for the most part for our own speech. So it says that if you run a platform, if you run a large social media company, or if you run, an online hot rod forum where you got about 80 users, you are not the person who's in trouble if one of your 80 users makes a bad post. So if I, use the hot rod forum to say that, Bill is a terrible driver and he should never be hired by Barrel's truck company, and he doesn't get the job, and I lied and I defamed him, then the person who's responsible for that bad conduct is me. It's not Lee who runs the site in my imaginary situation and isn't able to realistically fact check internet content, right? I mean, even once you have a small forum, it can't be your job. And Congress knew in the 90s the internet just wouldn't work if platforms, large and small, were held responsible for everything said online. So in most cases, the responsibility lies with the speaker, and we think that's how it should be. So and it's a big bet when someone tries to degrade Section 230. They're betting that their side will win out. I really feel that, and it's never a good bet. So we'll continue to oppose efforts to chip away at it.
Awesome. Thank you. We're going to take one more question, and then we're going to close this up. That last question is about fusion centers, and I'm just going to sort of expand it to include other sorts of police and law enforcement data sharing. Can you talk about fusion centers and how they threaten those looking to access reproductive or gender-affirming care and immigrants, even in states with shield laws that prohibit information sharing with out-of-state law enforcement to investigate and prosecute reproductive rights or gender-affirming care or immigration?
Yeah, sure. I can talk about that a little bit. I mean, it's a sad state of affairs because we've been talking about, all of the problems with the national security surveillance. But when we start talking about fusion centers and questions about immigrants and gender affirming care and repro, we're now back in the realm of ordinary law enforcement where we ought to have more rights. The problem is that because of longstanding concerns over crime and a lot of boogaboos around the border and around other kinds of supposed threats to American society, we've really instituted much more data sharing among ordinary law enforcement. And one example that Beryl's intimately familiar with is the rise of automated license plate readers, for example. And these are not specifically national security surveillance. They are not specifically law enforcement. They're just available to capture the locations and movements, which Bill was talking about earlier, of people, whether or not it's for private or for public purposes. And so there is very, very little effort to control any of this stuff at the federal level. Most of these fusion centers, most of the sort of national crime kinds of regional orgs live in a sort of twilight zone that is both governed by law enforcement rules, but at the same time subject to all sorts of data sharing requirements, whether it's with parts of the law enforcement community that focus on drugs or on other kinds of threats, and it's all sort of swooshes around in data piles. So we are in many of the, I'll be frankly a little political here, but in many of the blue states, what we are seeing, and we certainly work on this in California, is trying to make sure that the agencies and entities of the government, as well as private parties that have access to this kind of information, cannot share it with law enforcement in the other states. But this is a seriously difficult problem because in many of these organizations, the federal government is already there. And so the federal government, even if you kept even if you made sure there were no officials from red states that were in these fusion centers, the feds would still be there and they can still share. So it's a very, very difficult problem, but we're working on it in all the states to try to create more and more sanctuaries. Thanks.
Thank you so much, Lee. Unfortunately, that's all we have time for today, and I hope you all will join me in thanking Bill, Lee, and Joe for joining us for this conversation. And also thank you to everyone who contributed to the discussion in the chat, all the great questions, everyone who has been watching us from around the world. Digital rights begin with you. EFF has been a leader in privacy, freedom of expression, and innovation for 34 years, and we need your help to keep up the fight. So consider becoming a member today at eff.org/support-change. We hope you will continue these conversations about your civil liberties with your colleagues and your friends. Be sure to keep an eye out for the next segment of Affecting Change throughout the year. And thank you for joining us. We'll see you next time.
Thanks for everyone for coming. Thanks, Beryl.